How do state laws differ on search and seizure protections? In recent news, many people are asking how state laws differ when it comes to search and seizure protections. This topic has gained attention as individuals become more aware of their rights. Understanding these differences is essential, especially if you want to protect yourself during encounters with law enforcement. The Fourth Amendment of the United States Constitution sets a basic standard for search and seizure protections across the country. It guarantees that individuals have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. However, the application of this amendment can vary significantly from state to state. While the federal standard requires law enforcement to obtain a warrant before conducting a search, there are exceptions. These include situations like consent, plain view, or exigent circumstances. This federal rule applies uniformly across all states, but states can implement additional protections that go beyond these minimum requirements. For instance, some states have specific laws that requiring police to meet stricter criteria before obtaining a warrant. This means that in those states, officers may need to provide more substantial evidence or detail in their warrant applications. State courts also interpret search and seizure laws differently. In some cases, state Supreme Courts have determined that their state constitutions offer broader privacy rights than the federal Constitution. As a result, a search that may be permissible under federal law could be deemed illegal in that state. Another key difference lies in how states handle evidence obtained through unlawful searches. The exclusionary rule prevents illegally obtained evidence from being used in court. However, some states have their own interpretations of this rule, which may be stricter. For example, a state might exclude evidence in more situations or apply the rule to a wider range of cases. Traffic stops and vehicle searches also show variation among states. Certain states have enacted laws requiring police to obtain a warrant before searching a person's vehicle or electronic devices, such as cell phones. This contrasts with federal law, which may allow searches without a warrant in specific circumstances. It is important to be aware of your rights, as police procedures can differ widely between states. What is permissible in one state may not be in another. If you find yourself in a situation where your rights may be at stake, consulting a lawyer familiar with your state's laws is a wise choice. In summary, while the Fourth Amendment establishes a foundational level of protection, state laws can expand those rights, providing varying degrees of privacy and security. Knowing the specifics of your state's laws can make a significant difference in protecting your rights.